Welcome to Chat with the Lawyer. I'm your host, Walla Blagay, and today we are honored to have Mr. Jason Grant and Ms. Teresa Owusu from the DGO Law Group, one of the few African-American owned law firms in the district. And we are honored to have them on some very, very important issues. The first issue is custody issues, which is one of the most important topics we hear. Many people have access to cover this topic. And also wills and trusts. This is something that Prince George's County residents need to know about and want to know more about. So welcome to the show.
Thank you for having us.
Thanks for having us.
All right. So Mr. Grant, tell us more about the practice. How'd you get started?
Well, we got started in 2010. First, we met each other because my partners, they knew each other. Darian and Teresa knew each other before we met. And I and Darian also went to law school together back in 2002, 2005 at Howard University. And then about late 2009, we got together, started wanting to actually get together and start a practice for ourselves. And then February 2010 is when we opened shop.
All right. So now let's just jump right into the topic. Now, how many people want to know? They have a child, they want to get custody. Where do they start?
Well, the first thing they have to understand is that custody is determined by the best interest of the child. Maryland is one of several states that has a requirement that joint custody be one of the real goals of custody battles. Joint physical or joint legal custody or joint legal custody. So that's the first start. Secondly, people have to start thinking about what is about their situation that will best be in the best interest of their child or children. Thinking about where they're living, whether there's been a prior arrangement between the father and mother of who gets the custody or primary custody, as well as the relationships they have with other extended family members.
Okay. Now you say best interest of the child. Now tell us, what does that mean to a judge? Like when the judge is asking you questions about what is the judge considering when they're considering best interest of the child?
Well, like I said, living situation, whether the child is old enough to actually tell the courts that they actually want to live with either the mother or the father. The judge is also looking at who has primary responsibilities for the child, whether it's medical care, whether it's dealing with teachers in school. The judge is looking at those types of things.
Okay, and you say whether the child is old enough. What's considered old enough?
Well, the courts will look at the ages between 7 is when they start looking at it, but definitely 10, 11, 12, the judges will really take consideration of the child's opinion.
Okay. Well, there is a group growing, especially in Prince George's County. Some of my friends would be happy that I brought this up, that a lot of men feel that they are not able to get full custody of their child. In fact, there's been a movement in Maryland to push for the presumption of joint custody instead of just the best interest of the child. That will be one of the factors, presumption of joint custody unless you can prove otherwise. What advice do you have for these males in the fact that with the current law in place, how are they able to get custody, joint custody, or even full custody of their children?
Well, unfortunately, in family law, there seems to be a presumption that only the mothers get the custody. Reality is the judges aren't supposed to consider the gender of the parents in terms of best interest of the child. I think fathers should start thinking about what are they bringing to the table as far as their children are concerned, and how active have they been throughout the whole life, not just when there's a custody issue, but how have they been since the day of the child's birth, how they've been involved in that child. And when they've been involved in that child, they can show that they've been the one who's been going to school, talking with the teachers. They've been the one that have been engaged in medical issues with the child. When you have that type of relationship with the child, those are things that the judge is going to consider. A lot of times, what happens is the mother may be more involved in those things, but that's not really what's in the best interest. It's really all the factors in total are what the judge is supposed to consider.
Okay, interesting. And also, what about when grandparents are involved? Sometimes grandparents might not feel that the parents are doing a good job. They want to have the custody. What do they do? How do they go about gaining full custody?
Well, grandparents, as far as visitation and custody, is a very complicated issue. There has to, again, best interest of the child is what the judge has to consider, but oftentimes there has to be some real neglect there, extreme neglect on both parents' side to really consider the grandparents having the ability to get custody of that child. If that is present, that's when the grandparents can really assert themselves to really be involved in trying to get custody of that child or the children involved.
Okay, and when they say neglect, what evidence does a grandparent need to bring to the table when they talk about neglect? Because let's face it, no parent is going to take that lightly.
Right. Well, it has to be extreme neglect. It has to be, just really not caring for the child at all, or there's some sort of issue with the parents themselves, whether it's criminal issues or drug abuse or things like that. Those are the things that, are considered neglectful. If just the parents are, they have a different way of being an authoritative figure to their child, that's not enough. One grandparent can say, well, the parent likes to whip the child. That may not be enough if that discipline is not really so far gone. But if there's extreme beating and physical abuse and mental abuse of the child, those are things that the court will consider on both sides, whether the parents are concerned or the grandparents, and whether the grandparents really should have a say in having custody of the child.
Now, what about cross-jurisdictional issues? What if one person lives in one place? Like, let's just say the father lives in D.C., the mother lives in Maryland. How do they deal with the custodial issues in there?
It'll usually deal with the residency of the child. The main residency of the child will govern the jurisdictional issue.
Okay, and is there a difference between Maryland and D.C.?
There are some differences, more in terms of how quickly the process moves. In DC, it'll move very quickly. Sometimes you have cases done within a couple months. Maryland, it takes a little bit more time to get the issues going through, so it may take a few more months. But there's some small differences, but most of the time, the best interest of the child is really the standard amongst most of the states, and DC and Maryland follow that rule.
Okay, and also, why is DC faster? Is there anything? What would make DC a faster?
I think it's just more of a policy issue. It's not really more of the way DC does things, but I think DC just really likes to move things along when it comes to custody, support issues.
Okay. Now, let's go into just visitation. Is there a different standard with visitation? Because visitation is not the same as having maybe the child the whole weekend, or, how does visitation work?
Well, you also have to think about what's best interest of the child, but what's the parent's involvement. Sometimes the parents are not one parent may not be as involved as the other parent, and there may be issues of whether that one child has particular disability issues that only that parent is taking care of the most times. So when you're talking about visitation, it's in regards to how the other parent may be dealing with that child and whether that's enough. If it's not enough, the primary custodian will get more time, and the other parent may not have as much visitation rights or visitation time with that child. Other times, it's really within what the parents agree to. If the parents can come to an agreement about visitation, whether it's every other weekend or it's every weekend, the court will take those things into consideration.
Okay, and do we encourage, I know there is probably mediation. Some people feel there's a thought by many, even lawyers, that sometimes because the process is all decided by a judge, it creates friction, whereas if the parents can just do it on their own. So from your perspective as a lawyer, how do you help parents work together to come up with solutions? Do you do that, or how do you handle that? That's
mostly determined by the parties themselves. If the parties are willing to work things out, it makes things a lot easier. Oftentimes, whether it's custody issue or divorce, there's a lot of friction between the parties themselves, not just dealing with a courtroom. It's the parties themselves have a lot of friction, and thus you're not able to work things out outside of court. Most of the time you have to deal with things within court or through some sort of different type of agreement. Now,
in the Maryland courts or the DC courts, do they have mediation that they push parents to go through with custody issues?
Sometimes courts do advise mediation. It's not necessarily guaranteed or forced upon the parties, but it is something that the courts want the parties to engage in. Oftentimes, if the parents just don't get along at all, you'll have to go through some sort of court process.
I see. And also, when someone is newly divorced, if they consider divorcing, at that point, if they have children, custody issues immediately come up. How do you deal with that along with the divorce when you're advising your clients?
When you're considering their property issues as well as what's going to be best interest for the parties themselves. Are they going to be able to take care of the child? Are they going to be willing to do that? What is their relationship with the child? As well as, you're going through a divorce, That's very stressful. It can be very stressful on the children. You kind of have to advise your clients, be a little bit more respectful given that you have children involved in this matter. These are the type of things that the parents should think about, but oftentimes they're not thinking about it because they're so involved in divorce.
Exactly.
And they're so involved in the reasons why they're getting divorced. But the courts will also take in consideration the reasons for divorce. If the one parent decided to desert the other party, that's going to be consideration of custody issues as well.
Oh, interesting. Okay. So just moving out, not seeing the kids for a while could impact
the court will definitely look at that. If you've abandoned the family, the court's going to look at that as seeing that you're not necessarily as committed to that family, and particularly the children.
Interesting. Well, let's go into child support issues. Many complain about the child support process, that it doesn't consider a lot of financial issues. What is your take on that?
Well, I think the court is supposed to consider certain issues. Oftentimes, parties may feel that's unfair. Whatever reason that is, they may feel like, whether it's their wages have been garnished or something that's really been stressful on them, they feel like that's too much, and is the court getting too much in their business, and really is not in considering what they can afford. The courts are going to look at who's the primary custodian, and they're also going to look at the normal cost of raising that child. They're going to look at how much you can afford, but they're mostly looking at what has been the cost of taking care of this child all along, with its medical costs, child care costs, and things like that, and how much it's going to take to really provide for that child. Those are the real things that the courts can consider. They will consider how much you're making or how much you're not making, but the other issues are what's most important.
Now, what if you get the final judgment and you're like, look, this is way too much. I cannot pay this. Now, often, what can you do for an adjustment?
You can do a motion to modify a judge's order based on particular factors, like whatever your income is, your earned wages. Those things are going to be taken into consideration once you do a motion to modify, and hopefully the court will go in your favor. Sometimes they won't, but they will take those things in consideration. And they'll also take in consideration what the primary custodian has to offer as far as their earned wages.
Okay. Now, what if you simply just stop paying? Money was good then, and then you just can't pay anymore now, and you decide, I don't have time to go to court. I'm just busy, and I can't pay this. No.
You should really let the court know before you decide not to do that, because you can possibly be held in contempt. The other party may file a motion for contempt so that you'll have those issues happening. There's also issues of wage garnishment that you're going to have to watch out for because of not being in compliance with your support order.
And does the court give you notification before they completely garnish your wage? Like, how does that process work?
The process usually works that the court, well, first you have to actually go through the wage garnishment process. You have to petition for that. And then the court will then, there has to be a process of contacting the employer, and then the employer has to, be notified, and then they have to notify the employee, and then the process begins.
Let's just say you have custody of the child, and they are, and the person, you can't find the person stops paying. At that point, what are they supposed to do to make sure that the person pays it? Especially, what if they can't find the person?
That's where it becomes very difficult. You're going to have to go through some sort of process to try to find that person. If they have just left not only the state, but you just can't find them, you're going to have to figure out some other way to really get in touch with them, contacting family members, whatever you have to do to really get them. But you can only hide so much. And
do you help with that as an attorney?
Well, we try if we can. We may tell the client that we may have to hire a private investigator to find where that person is. Like I said, it's hard to sort of disappear. If you're getting a job somewhere, your tax information is going to pop up somewhere. So you're not going to be able to hide that well, but it could happen.
All right. Well, thank you so much. This has been really good information. And please stay with us, because when we come back, we're going to talk about wills, trust, a very important issue. Thank you.
Never look a howler monkey in the eye. We built the entire library out of recycled bottles. Fried ants are delicious.
We finished a clinic in a rainstorm.
Really?
That was a confidence builder.
My students actually ended up teaching me. So I learned this dance. I'll show you this dance.
Yeah. In la keg,
a la king. The classroom was more of a class tent. I think managing a sales team is tough. Try working with 5 different villages. My alarm clock was a rooster. Beans for breakfast, beans for lunch, beans for dinner. We ate a lot of beans. I learned a 3rd language. My seatmate on the bus was a goat. Always include the village elders. Always. My morning commute was by canoe. After 2 months, I was ready to quit, but after 2 years, I didn't want to leave. I didn't know I had it in me.
Turn 2 years of service into a lifetime of experience.
Welcome back to Chat with the Lawyer. And now we're going to go into the wills discussion, a very important discussion. And Ms. Owusu from DGO Law Group is going to lead us into it. So tell us about how you got into this practice.
So the practice started in 2010 as a general practice. And I think as more clients came through the door with a variety of cases and experiences, we just began to take on more and more of those types of cases.
Okay, that's good. So let's jump right into the issue here. Many people they kind of feel like you got to be on your deathbed before you think about a will. What advice do you have for them?
Well, I think there's definitely a misconception that either you have to be on your deathbed or you have to be a millionaire in order to have a will. And that's simply not true. Anyone needs a will and should consider getting one because the will offers various benefits that take place once the person passes away. But in taking the steps to plan early on, you can eliminate some of the issues that happen in the future. Okay, so how young have you in your practice done wills for somebody? How young has a person been? For wills, we've generally tends to be more middle-aged clients, but I know that we definitely are encouraging younger clients to consider estate planning documents because, again, without a crystal ball, there's no telling what could happen in the future. So the earlier you can plan those documents, the better. And when you say middle-age, state of age, like an age group? So generally, mid to late 40s, 50s. I see. And what do you say younger, what would you define as younger? So more of the millennial set, I guess, so to speak. 20s and 30s, yeah. Okay. Now, what are you telling someone in their 20s and 30s that's like, look, I just got a job, or someone in their 30s like, I just started my real profession at this point. I don't have that many assets. Right. Well, again, I think there's a misconception that you have to have a ton of assets. You have to be an Oprah or a Rockefeller to have assets. But you'd be surprised if you take the time to sit down and list all of the property or assets that you do have and the value, you actually do have something that you would like to designate in a will. Okay. And also, what if you own a home? Is that something if you buy a home, should you consider just drafting a will at that point? Definitely. And especially when it comes to families with minor children, having a will definitely puts into place some protections in terms of a guardianship in case one of the parents or a surviving parent is no longer available to take care of the children. So it definitely puts some safeguards in place. And so what do you include in the wills when you're drafting them for clients? So to start off, you definitely want the drafter of the will to be of a legal age, and you want them to have the mental capacity, meaning they understand what they're getting into, what they're drafting, the amount of assets that they have that would go in the will. So those are some of the things that you want to keep in mind. Okay. Now, what about, because a lot of times what you find, especially for those in 30s and 40s, is something like they can get an accident or cancer or something like that can happen. Or there was a case I know where someone's just fell into a coma. Something happened, they fell into a coma. They didn't have any medical directives. Do you include medical directives in your will or something like that? Yes, so they kind of go hand in hand. And just to be clear, sometimes it can be confusing. A will is definitely separate from a living will, or what's also called an advance directive, in that a will takes place usually upon the person's death. But an advance directive or living will can take effect if the person becomes incapacitated or has an accident or something along those lines. And in that living will, you can dictate exactly your end-of-life medical care instructions. For example, what life-saving measures you'd like to have in place, whether you'd like to have your organs donated. So some of those issues are also outlined in the advance directive.
And so advanced directive will determine maybe if you, do you want to be, how long do you want to stay alive, if you fall in a coma, things like that. I mean, that's something scary for most people. How do you handle clients who are...
So in general, talking about wills and sort of future planning, estate planning documents, it can be an uncomfortable discussion. But we definitely encourage individuals and families to start the dialogue, because by starting the dialogue, you can eliminate some of the anxiety for planning for those difficult decisions in the future.
Okay. So so then you sort of draft a will for the person and that type of thing. Where do they store it? Like, what happens? Do you keep it?
So that's a great question, because I think oftentimes people want to have, this will designated in a safety deposit box, but it's crucial because at, certain points, your family members might not have direct access to that safety deposit box. So you want to have a will at least, you share with a couple family members. You're not going to distribute it widely, but you at least want to have some people that you trust that would know where to find the will if necessary.
Okay. And can somebody change their will? Like, once they draft it up, can they change it after a year or two, or decide it?
Yes, we definitely recommend keeping the will updated, because life is ever changing. Based on the number of assets you might gain, you're changing, or you're expanding family potentially. So you want to make sure that the wills are constantly updated so that they meet the needs of your family.
Okay. And now, if somebody wants to develop a trust, tell us what's different between a will and a trust.
With a trust, it's a legal document that allows you to specify certain benefits to pass on to beneficiaries. And that is often managed by what's called a trustee. And the person passing on those benefits is what's called a grantor. So there are a variety of options for a trust. And depending on the needs or the purpose you have in mind will dictate the form of trust that you establish.
Well, give us an example. Why would somebody get a trust versus a will?
So a trust, one benefit of the trust is that it bypasses the probate court system. So the trust gives you a little more control in terms of how you want your assets distributed. And for example, if you do have a number of assets that you don't necessarily want to have exposed through the court system, you kind of get that privacy in that you have the control of managing those assets within the trust.
Now, you said probate system. Explain that.
So typically with a will, once the will is located, you can submit it through the court system, and then an estate will be opened. And part of the issue with that is sometimes people don't have wills, and which is what's called intestate. And so with intestate, you run the risk of not having your wishes really carried out the way that you intended.
Now, explain that, because that's important. Some people have a mother who is fine or a father who's fine, and all of a sudden, next thing you know, bam, like that, they're gone. And then they are one of the sons that's trying to pay the bills and make sure that they go through their parents, maybe their 401k or their pension to get all that stuff, and then they're told, you don't have a power of attorney. You can't do anything. So what walk us through the steps.
So with a will, generally, some of the elements you'd like to include is the designation of a personal representative. So automatically, if you do happen to pass on, the court will know who will be managing your affairs. And also, typically, you would like to have a power of attorney drawn up as well, so that the person will have legal access to your assets if needed, so that they can smoothly run through the process of how your assets will be distributed.
Now, what if you don't have those things? John's mom just passed away. It was unexpected. He didn't know. He has 4 other siblings. His mom has 3 other siblings, and they're trying to pay bills and, get to the pensions, get access to the funds, and even to the house. They're determining what would John do?
So if you don't have a will and are intestate, what typically happens is that a family member can go to the court and establish the estate and move to be appointed as the court-appointed representative for the estate.
Can John just do that? Can he just go to the court? He just goes to the court. What does he file?
So if you have a will, you can definitely file the will. If you don't have a will, you can just file for a petition to be appointed. And in that, there is a certain hierarchy of who can be appointed, typically family members, and then a certain hierarchy down the line. And with that, there's a whole process for that as well. So you have to
So go through the process.
So there's a marshaling of assets for one. You want to be able to have an inventory of all the property the individual had. And also there's a publication process as well. So once you file the will or once you establish the estate, there's a certain period of time where you have to publish, or it could be in a newspaper, or just give notice to creditors that the estate has been established. And so any creditors who have outstanding bills against the decedent may also try to stake their claim as well.
Interesting. Well, now I said that John had siblings, and his mom had all these other siblings, and she had a husband too. But he's trying to be appointed. What would the court consider? What happens?
So family members take priority for sure, especially if it's a spouse, that would take priority. And then it goes through a certain hierarchy. So if there's children involved, if there's siblings, it just depends on the family dynamic about who exactly is in the pecking order, so to speak, in terms of who has access to the estate.
And what if John is fighting with his father over that? So who would be petitioned?
So, contestants to the position or appointment of the personal representative are not uncommon. Unfortunately, when someone passes, certain family dynamics do come to the surface, and there may be contention about who should be designated as a personal representative. So if there is a true conflict, true disagreement about who should be appointed as a personal representative, you can actually petition to either try to have the personal representative removed, or at least make it known that you do contest that particular individual being the personal representative.
And how can you win?
Well, one, you do have to show a number of circumstances. If you feel the person who is attempting to be appointed as a personal representative, if there's a certain history, possibly their fiduciary duties would not be met because of pre-existing issues with being financially responsible. If you know that flat out that the decedent would not have wanted a certain relative to be the personal representative, all those things can be considered.
Well, thank you so much, Ms. Owusu, for coming on the show and talking about this important issue. Of course, I'm sure there are many other topics we can talk about, both family law and wills and trusts, for hours. But thank you all so much for coming on this show, and I'm sure that the residents of Prince George's County appreciate it. And thank you for watching Chat with the Lawyer. If you want to hear more, you can go to chatwiththelawyer.tv for more of the episodes. Thank you for joining us.
I've never been the type to ask for help, but I had enough.
Thank you for calling the Veterans Crisis Line. How can I help you?
Life still has its challenges, but my family and I can deal with them better now. Veterans Crisis Line. It's your call.
To someone going through a difficult time, one simple act has the power to make a difference. Hello.
Hi, Dad.
Reach out to the veterans in your life today. Let them know they're not alone.